If you don't have a will, the position really is that your estate would be divided in accordance with what's known as the rules of intestacy. The rules of intestacy are a set of laws that provide where your estate is to pass if you haven't left a will. And the laws will go into great detail about where the estate will go. For example, if you die while married, then some of your estate will go to your spouse, not necessarily all of it, and a lot of people don't realise that. And you really need to do a will to provide for your spouse. So if you died without leaving a spouse and without leaving children, your estate may well go up to your parents, which may be undesirable because a lot of people have family conflicts and you may not want it going to your parents. Equally, your parents might be wealthy enough and they might not want your estate because it makes their estate larger and their estate could be taxable again. It's never too late to do a will, but if you're a property owner, you're married, you have children, or you're cohabiting with a partner, it's a very good thing to do because of course you can specify who is to get your estate in the event that anything would happen to you. A will help you provide for your loved ones and the people that are special to you and that you care about. And you should also have sort of moral obligations for people that you should look after in case you pass away. Because potentially there could be a large number of people who might be able to claim against your estate if you didn't make adequate financial provision for them. So it really is beneficial for you to sit down before anything happens to discuss where your estate should go so that you can consider all the moral obligations of all the people that you should consider within your will. A will's not all about the finances. You can specify in there who's to look after your children. For example, if you've got children under the age of 18, you can actually say who should look after the children in case you were to pass away. And the will is really a good opportunity to make your wishes and thoughts known while you are still living as to who should bring the children up and who the appropriate people are to do that job, or who you would entrust to do that job in a manner that you are happy with and a manner that you would have carried out. The disadvantage of doing a homemade will is it doesn't come with inheritance tax advice, and what you put in there may be catastrophic for the purposes of inheritance tax. One of the benefits of coming in and seeing us as solicitors is you can of course tell us what your circumstances are, you can give us an indication of what your potential wealth is and the size of your potential estate, and we can tailor-make something specific for your needs in an attempt to reduce any inheritance tax liability. You should really consider who you want to carry out your final wishes, and these people are known as executors. You should be choosing up to 4 people, and if you have children you'll need at least 2 executors, but they should be people that you trust and that are familiar with your working finances or could easily familiarise yourself with your finances, and more importantly people that you trust to do the job. And one of the benefits of doing a will is of course you can actually say who the people are that you want to do this. In the will you can specify who you want to leave money to. There may be people that are very special to you that you think, well, you'd like them to have a little bit of money, and they may have lifelong pursuits that they've always wanted to follow, and of course you can give them some money to help follow those pursuits if that's what you wanted to do. You could also leave money to charity. There are many people who would like to leave money to charity, and if you have charities that you support and you're an avid supporter of, you can of course remember them in your will. If you don't do a will at all, of course, your estate in England would be divided in accordance with the rules of intestacy, which are the rules that provide where a deceased person's estate is to pass if they die without leaving a will. And if you own property abroad and you haven't left a will, well, it'll be down to whatever the rules are in that jurisdiction to deal with your estate, and they may well not be what you want. Therefore, the advice would always be, if you own property abroad, you should see a solicitor in that jurisdiction and get a separate will for that jurisdiction, and you should see a solicitor here and make sure any will that we do for you here is limited to your estate in England and Wales and doesn't cancel out any will that you might have abroad. Your circumstances can change, and for example, if someone were to get divorced, this is a good triggering event to review your will, because of course it's unlikely that you'll want monies to go to your ex-partner, and the law would automatically write out the ex-partner anyway. So that is a triggering event to come in and change your will. Also, equally, if later on in life you get remarried, you should come in and change your will, because a lot of people don't appreciate that if you get remarried, your old will is null and void, and that you should really consider your circumstances again and keep your will regularly updated. It's a life document. It's not a document you do once and forget about. It's a document that you should come back and revisit as life changes for you. And also, more importantly, always look to the will if ever there's a birth, death, or future marriage or divorce of anyone within the family, to check once again that the will still does what you want it to do. If you've got a husband and wife, husband dies, leave everything to his wife. Wife can't live on her own anymore. She needs to go into a care home and she needs some sort of assistance. Of course, because she's just inherited her husband's estate, she's going to be worth a lot more money. Therefore, a lot more money is going to be exposed to potential nursing or care home fees. Whereas if the husband had died, and say for example you had children together, you could pass the husband's estate down to the children, which of course protects at least half of their joint estate from nursing home and care fees. A will speaks from the moment you pass away, whereas a lasting power of attorney will work during your lifetime and it actually dies with you. The point of the lasting power of attorney is if you've got property and finances that need dealing with, if you weren't very well or you're finding it difficult to get out the house or go down to the banks and what have you, you can appoint people that you trust to do the job for you, which would mean they would be able to access your finances and deal with your day-to-day finances for you. Because of course if you're ill and you haven't got a document such as this, it can often be a concern as to who's looking after all the bills for you, which can often make things a lot worse. So the benefit of coming in and doing a lasting power of attorney is you can of course specify who you want to deal with everything for you. The other thing you can do is you can also do a lasting power of attorney that deals with your personal welfare. That means you could appoint someone to make more personal decisions for you. It's important to note this document would only ever take effect if you lost mental capacity. So if you didn't really understand what was going on anymore, you could have someone making decisions such as what you're going to wear in the morning, as to what you're going to have for lunch. It also goes a lot further than that. If you were very ill or you were critically ill, you could have an attorney discuss with the doctors whether or not they are or they aren't to continue treating you. So you can leave them with that power during your lifetime to make decisions on your behalf.